We don't agree with that Supreme Court opinion. We don't like it, but we are duty-bound to follow it. A wonderful, eloquent statement. So, the Chief Justice raised two arguments. The first was that the order was not an order, even though it said order. It was a status update. That he was just informing the probate judges that the Alabama Supreme Court hadn't ruled. Here's what the Court of the Judiciary said. The Court does not find credible Chief Justice Moore's claim that the January 6, 2016 order was merely a status update to the state's probate judges. And then it further said, as noted, Chief Justice Moore's use of case law in the order was incomplete, misleading, and manipulative. We find that when coupled with the intentional omission of binding federal authority, the clear purpose of the January 6 order was to order and direct the probate judges, most of whom had never been admitted to practice law, to stop complying with binding federal authority until the Alabama Supreme Court decided what that federal authority would be. Again, hit the constitutional nail right on the head. The probate judges were duty-bound to follow Judge Grenade's injunction. And the Chief Justice had no right to tell them otherwise. It was an order. It was an order that put the probate judges in jeopardy, and the Court of the Judiciary said that. The second was that the Obergefell decision only applied in the 8th Circuit. And until there was a case from the 11th Circuit, people in the 11th Circuit didn't have to follow it. Well, that idea had long since been undone by a case called Cooper versus Aaron. The Little Rock desegregation case. Public officials in Arkansas said, wait a minute, we're not named defendants, we don't have to do anything. And in Cooper versus Aaron, the United States Supreme Court, in an opinion signed by all 8 justices, because they wanted to make sure everybody understood it, said, no. The law in this country is that once the Supreme Court rules, state officials, state court judges are obligated to follow that ruling. Now again, one of these interesting twists in the case. In his first case involving the 10 Commandments, Chief Justice Moore had cited Cooper versus Aaron for the very proposition that we were citing it for in this case. But because it didn't work for him, he didn't like it that way. So the case then gets appealed to the Alabama Supreme Court. But this is an unusual case. Because of these memos and things, every member of the Alabama Supreme Court had knowledge of the facts of the case, so they had to recuse themselves. So there then occurred a drawing in the Alabama Supreme Court where the names of all retired judges, District Circuit, Civil Appeals, Criminal Appeals, and Alabama Supreme Court were placed in some kind of machine, I wasn't there, and a random draw of those folks constituted a 7-member court to hear this appeal. And so in April of 19th of 2017, that specially constituted court unanimously affirmed the decision of the Court of the Judiciary, finding that Chief Justice Roy Moore would be suspended for the rest of his term. So, what's this case all about when all is said and done? It's about 2 things. It is about the rule of law. That once the United States Supreme Court rules, if there was a game of constitutional chicken going on below, that game is over. But more important to me, it's about the courage of the people on the Court of the Judiciary and the Judicial Inquiry Commission. These are people that serve without compensation, that got immense amounts of grief about this case, but absolutely did the right thing. So we really need, as a bar, to celebrate these folks and their adherence to the rule of law. They didn't like the Obergefell decision. A lot of them thought it was wrongly decided, but you know, it was the law of the country, it was the law of the land, and we're duty-bound to follow it. There is a wonderful article written by Judge Pryor about his experience in the first Roy Moore case that I highly commend to you. It's called Moral Duty and the Rule of Law. If you will If you're interested in reading it, send me an email. I have a copy of it electronically. I'll send it back. But he also deserves a huge amount of credit for taking on that case. As a Republican Attorney General in a very, very conservative state, you can imagine the sorts of grief he got when he undertook the first prosecution. So it really is a time to celebrate the people of this state for the good things that they have done, and this is one of them. So thanks, and I'll entertain questions. Yeah?
Can I briefly add a funny aside to all of this?
Sure.
All right, so in 1995, or I guess 95 or 96, after my dad ruled that Roy Moore's use of prayer in the courtroom was unconstitutional, and then that order got amended for him also to remove the Ten Commandments. Something very similar to what you're talking about happened. Roy Moore had this big press conference. It was on the Capitol, blah, 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 blah. Fast forward to 2003. I have graduated from law school. I started clerking at the Alabama Supreme Court with Justice Harwood. On the third day that I was clerking, I think it was like September 7th or 8th, the only person that was in the elevator with me was, at that point in time, Chief Justice, was he Chief then? Supreme Court Justice Roy Moore, and he said, "Oh, what are you doing here?" I was like, "I was, third day at work." He said, "Who are you clerking for?" I said, "Justice Harwood." And he asked me what my name was. I said, "Charles Price II." And he looked at me, and then he never spoke to me again. And then he got removed in November of that year. But if nothing else, he is consistent.
Did he get fees taxed to him? But who pays the legal fees for this? If you're
His lawyers represent him, as far as I know, without charge.
So does the state tax? I mean, does he have to pay fees for?
There is no cost taxing procedure that I know of in this process.
So do out-of-state lawyers have to be licensed in Alabama, or can they?
Pro hac vice.
Okay.
Yeah.
About the memo, he wanted a ruling, but was there an underlying case? Was it the API case?
It's the API case, yeah. The API was decided in March of 2015. Then in June, they decided to ask for briefs, those sorts of things. So they got a bunch of petitions. So in June 2015, after Obergefell has decided, they have some pending matters in that case. And that's what he was trying to get them to rule on. And actually, some of the language in the memos is you're duty-bound to rule timely on these issues. You're not ruling timely. And I'm trying to remember exactly. There were some citizens wrote letters complaining about the lack of timely resolution of the matter. You can imagine who those citizens were. Anything else? Yes?
Is there any, I don't know if you can really get into his head, Dean, but is there any sense, one, if he had just said, you know what, I did get a little out of control, could y'all have resolved that case if he had just said, you probably are right, I was a little overwrought on this?
I mean, I got in it after all that would have occurred, but there was nobody that I knew working on that case that took any pleasure at all in what had to happen. Nobody. I think we would all much rather have that than some informal resolution of the matter. Nobody liked doing what we had to do.
But was there any effort by his team or his lawyers to say, let's try to resolve this?
There are confidential matters that related to that I can't discuss. Anything else? Yeah.
What was one of the more taxing part of you trying to be the prosecutor in this case?
It really wasn't bad. I mean, talking to the people that were involved in the first case, I mean, they had people walking around the Supreme Court blowing ram horns and that kind of thing. The only concern was we eventually got this right. The first day in August, they wouldn't let us go up into the building on the elevator. So we had to walk around and walk through the crowd of people that were saying we'd all rot in hell. But no, I mean, this was, as I said, the Chief Justice's lawyers were courteous. The Chief Justice was courteous. I mean, no, the hardest part was, I think, the work that had to be put into the case. But, our lives were simple compared to the lives of the people in the Judicial Inquiry Commission and the Court of the Judiciary.
And then follow-up question, did your lives change after the case when you came back home, or did you notice anything different?
Early on in the case, when I first got in it, I got 500 emails from people saying I was going to rot in hell, essentially. And they all had the same misspelling, so they all came from somewhere. But after that, nothing. Again, contrast that to the first go-around. Talking to the people on the Judicial Inquiry Commission, they had people sitting outside their offices. I mean, it was much, much different. No, and from an intellectual standpoint, this was, if you're a federal court nerd like I am, man, this is really interesting stuff.
I mean, was there any attempt to take his law license, or does he still have a law license?
I do not know.
After that first trial in the Supreme Court, there were so many people on the steps of the Supreme Court, and they were selling hot dogs and whatever, that the Supreme Court, after it was over, had to have the court steps sandblasted to get the mustard and the ketchup off.
Yeah. Hopefully one would have those. But again, the last thought I'd like to leave you with is to really celebrate the courage of the people on the Judicial Inquiry Commission and the Court of the Judiciary. And though some of those people are gone, some of them are still there, but we are fortunate to have people that are willing to do that. And when all is said and done, ingrained in all of us is the rule of law and the importance of it. So, thank you all.
Thank you.
I have a granite plaque for you. It says, "In grateful appreciation, Arthur D. Shores, Robert S. Vance in the court, Birmingham, Alabama, American Indians of Court, Chapter 292. Thank you. Yeah. Enjoy it.